Yes.
Lord, may it please you, I appear for Birmingham City Council in this matter. My own friend, Mr. Drabble and Mr. Royston, appear for the respondent, Mr. Bravington. And the first matter this morning is my application for permission to include within the bundle one document, which is a short witness statement by a police officer who has my Lord, the reason that we asked for it shortly is that the respondent, in particular, that the respondent's notice on page 21 at ground 1B raises a point as to whether or not, even if section 233 of the Local Government Act applies, service was in accordance with that section. In my respectful submission, it's important that the court is able to see what the evidence of service was. This document was before both the district judge and the circuit judge below without that being contentious. And in my submission, it's right that the court should see what the evidence of service was. It's a short document, doesn't it?
Mr. Drabble?
I don't agree to the application. I'm not going to spend a lot of time on it.
No.
But our short point is that on the basis of which permission was given for an offend to appeal, this issue is irrelevant, and the court has ample material to see the outline one way or the other of anything raised by the respondent's notice.
And this is way at the end. But
this is way at the end of the argument.
Yeah, thank you very much. We'll give permission for it to be used.
My Lord, I'm grateful.
Thank you, Mr. Drabble. Yes.
This then, my Lord, is the local authority's appeal from the decision of His Honour Judge Boora, also made on appeal on the 4th of February of last year, dismissing the authority's appeal against summary judgment having been granted by District Judge Phillips in relation to a possession claim that they had brought against the respondent. My Lord, the ground of appeal for which permission was granted by Lord Justice Snowden is a relatively short one.
Yes.
And is simply whether section 233 of the Local Government Act 1972 authorised service of the notice, leaving aside the point taken by my learned friends and their respondents' notice, by taking it to and leaving it at the property, or whether service had to be effected in accordance with common law rules. My Lord, what I would propose to do is to take my Lords, first of all, to section 233 and then the statutory scheme of the Housing Act 1985, then to the case of Enfield, London Borough Council and Devonish, which is the decision of this court that led both the judges below to come to the conclusions that they did, and then to make my brief submissions on what it all means.
Thank you.
Then I'll deal separately with the respondent's notice, if I may.
Yes.
So, my Lord, if I could first of all go to the authorities bundle. I should have said at the beginning, I apologise, I've handed up this morning.
Well, what we've got, well, I've certainly got an original authorities, an amended bundle. I couldn't, for myself, work out what the difference was between the original and the amended. And then we've got the two additional authorities this morning.
I'm grateful, my Lord. The reason that the bundle was amended was certainly in my copy, when I looked at it electronically, it seemed to include a large number of things that were in duplicate.
Okay, yeah, it does, yeah. But that's all.
Yeah, that's all.
Okay, it doesn't add all. Okay, thank you.
No. My Lord, on page 3 of the bundle, my Lord's using hard copies behind tab 1, we find section 233 of the Local Government Act 1972. And I draw attention to, first of all, in subsection 1, the language that provides that subsections 2 to 5 below shall have effect in relation to any notice, order, or other document required or authorised by or under any enactment to be given to or served on any person by or on behalf of a local authority or by an officer of a local authority. And I submit that this is plainly very wide language. Can't really take it any further than that at this stage. Subsection 2 provides how service may be effected. It may be given to or served on the person in question either by delivering it to him or by leaving it at his proper address or by sending it by post to him at that address. Now, in this case, the document was not posted. In my submission, it was left at his proper address. There is nothing in the language of this subsection that requires it to be left in any particular way at his proper address. The learned friends, I think, will say it needed to have been put through his letterbox. And I respectfully submit that that's not what the Act says. And one of the additional authorities I handed up this morning, the Newey and Jones case, I say supports the proposition that it can be left at the address in any, effectively in any reasonable manner, and that no further gloss on the statutory language should be applied. Subsection 3 is not of any particular relevance as it relates to bodies, corporate and partnerships. Subsection 5 allows for the situation where the recipient of the document has specified a different address within the United Kingdom other than his proper address within the meaning of... Sorry, I should have dealt with subsection 4. Subsection 4, the proper address of any person to or on whom a document is given or served shall be his last known address. And I don't think we need to go into the provisos which relate again to corporate entities. But by subsection 5, if the person has specified an address other than his proper address, then the authority can serve the document on either the proper address or that other address. The other address should be treated as his proper address. Subsection 7 makes specific reference to the case of land where the name and address of an owner, lessee or occupier cannot, after reasonable inquiry, be ascertained. And there the document may be left, may be given or served either by leaving it in the hands of a person who is or appears to be resident or employed on the land, or by leaving it conspicuously fixed to some building or office on the land. But that obviously relates to a situation where the name and address can't be ascertained. My Lord, subsection 1 is said to be subject to subsection 8. Subsection 8 applies to documents relating to, authorised to be served or required to be served on a person on behalf of the chairman of a parish meeting. It's not particularly relevant to this in my submission. And subsection 9, the provisions don't apply to documents to be served in court proceedings. And by subsection 10, except as aforesaid and subject to any provision of any enactment, including the foregoing provisions of this section, the methods of giving or serving documents which are available under those provisions are in addition to the methods available under any other enactment or any instrument made under any enactment. There's then a definition of local authority in subsection 11.
You're not any of those particular things, but you are a local authority.
We are a local authority. We are not, my Lord, no. We're not any of these additional entities.
Going back to subsection 10,
My Lord, yes.
do you know of, or has anybody found any enactment or instrument which excludes the provisions of this section?
I'm not aware of any.
Okay.
I haven't found any.
No.
My lord, I don't need to take you to section 270, which is behind that, but there are further definitions of local authorities in that subsection.
Which page is that?
That's page 5.
And just to be absolutely clear, so the local authority means the county council, district council, London Borough Council, or parish council. What are you? I mean, you obviously are a local authority.
We are a district council.
You're a district council.
Birmingham City Council, Birmingham City Council is a district council.
Yep.
Styled a city council for historical reasons. It is now also a unitary council, but that doesn't stop it from being a district council for these purposes.
Yep.
My lord, can I move on to tab 3, to the provisions of the Housing Act 1985? There are quite a number of provisions from the 85 Act in the bundle. I'm hoping to be able to take them quite shortly, because the only point to make about them in my submission is that the entirety of the arrangements for local government provision of housing is statutory. And so I've put in a number of the provisions of Part 2 of the Housing Act 1985, more by way of illustration of that, and the extent to which the statute has made provision for local authority housing, rather than because I submit anything specific terms on those statutory provisions themselves. But what I'm hoping to do is give a flavour of the topics that they cover, rather than going into them in detail, unless going into them would be of assistance. But I start on page 10 of the authorities bundle with a further definition, this time of local housing authority, which is a district council, a London Borough Council, the Common Council of the City of London, a Welsh county or county borough.
Sorry, which section is this?
Section 1 of the Housing Act 1985, which is just behind tab 3, page 10. And I don't think there's any dispute that Birmingham City Council is a local housing authority. Can I think probably I can go next to section 8 on page 19, which is in part 2 of the Act. And the point to make about section 8, respectfully, is that even from the a point of time before the authority actually provides any housing, it has duties to consider the conditions of housing in their district and the needs of the district with respect to the provision of further housing. They must review information that's brought to their notice. And they need to consider, in addition, the needs of people who live in houseboats or caravans. Section 9 on the next page. Particular powers and duties are given to local authorities in this area, and they're subject to the regime here, so that they have specific power to provide housing accommodation by erecting or converting, by acquiring houses. They can enlarge, alter, repair or improve them. They can dispose of them, but in some cases they need the consent of the Secretary of State. But they're not required by subsection 5 to hold any houses or land for the purposes of Part 2. By section 10, on the next page, they can fit out and furnish houses, they can sell or supply furniture to the occupants of the houses provided. By section 11, on page 22, detailed provision for their powers to provide facilities in connection with housing, for obtaining meals and refreshments, doing laundry, and they may make subsection 2 reasonable charges for meals and refreshments or laundry facilities. And there are detailed provisions about licensing, alcohol licensing. Section 11A on page 23, they can provide, in connection with housing accommodation, welfare services. Section 12 on page 24, they can
Do we need to
provide...
go through all of these?
No, my lord, probably not. Section 12, they can provide shops
Yeah.
and recreation grounds,
Yeah,
streets.
yeah.
In some cases, they can exercise their powers outside the district. Perhaps I can just turn to page 29, section 17.
Yes.
They can acquire land in order to build houses. Section 18, if they do acquire a building that can be made suitable as a house, they must forthwith to proceed to secure that it is made suitable. And perhaps also section 19. Subsection 1, they can appropriate for the purposes of this part any land for the time being vested in that. But by subsection 2, if they do acquire or appropriate land for the purposes of this part, they can't, without the Secretary of State's consent, appropriate any land of any part of the land consisting of a house or part of a house for any other person. So once there's a house on it and it's been appropriated for Part 2 purposes, they need Secretary of State's consent to take it out of the provision of housing. And then the last two of these provisions, section 20 creates a set of sections relating to their housing management powers. I've only included section 21, which vests the general management, regulation and control of houses in the authority. There are further sections, but the point I think that I wish to make about all of that is simply that this is a highly regulated statutory regime. And the situation in this case is not simply that there is an act of parliament that says if you want to do X, you have to serve a notice. Everything about local authority housing is highly regulated by statute. We come on to the actual provisions of the Act at page 34 relating to secure tenancies themselves. And again, hopefully I can take this relatively quickly. By section 79 on page 34, a tenancy is only a secure tenancy if the conditions described in sections 80 and 81 as the landlord and tenant conditions are satisfied. There are, by subsection 2 in schedule 1, which we don't, for my purposes, need to go into, a number of types of tenancy that, even if those conditions are satisfied, can't be secure tenancies. But the general principle is that a tenancy can only be secure if landlord and tenant conditions are met. And turning to section 80, it's notable in subsection 1, which has been heavily amended, that prescribes the type of body that can grant a secure tenancy. There is, in this, excuse me, in this reproduction of the Act, slightly confusingly, some of the wording in subsection 1 and 2 that's been repealed has been included but in italics. So it's now the case that with very few exceptions, and I don't think this is in dispute, housing association, for example, cannot grant a secure tenancy. They grant assured tenancies under the Housing Act 1988. I'm saying a huge amount of terms on that, but just for the sake of clarity. And we see that in the notes on page 39. I don't think it's particularly in contention, but just 3 entries up from the bottom. 4 entries up from the bottom, it refers to subsection 2 having been repealed with savings by the Housing Act 1988, etc. That there were savings for certain tenancies that had already been granted, that had been secure and could in some cases continue as secure tenancies. But since 1988, housing associations, or as in England at any rate they're now referred as private registered providers of social housing, don't grant secure tenancies, they grant assured tenancies under the Housing Act 1988. And as we'll see in a moment by Schedule 1 to the Housing Act 1988, local authorities can't grant assured tenancies. They can only grant secure tenancies, again subject to certain other matters that I don't need to go into here. So the landlord condition requires that the landlord be one of a number of specified bodies, which includes a local authority. The tenant condition on section 81 is that the tenant is an individual and occupies a dwelling house as his only or principal home, or if it's a joint tenancy, each tenant is an individual and at least one of them occupies the dwelling house as their only or principal home. And there are a variety of new additional provisions which I don't think, for my purposes at any rate, it's necessary to go through, and some of which are not yet in force in any event. But where I think we go next is to page 53, section 82. Subsection 1, a secure tenancy which is either a weekly or other periodic tenancy or a tenancy for a term certain, ignoring the words underlined, is subject to termination by the landlord, cannot be brought to an end except as mentioned in section 1A. The tenancy may be brought to an end by the landlord, A, obtaining an order of the court for possession, and 2, the execution of the order. I don't need to go further than that, but it's notable in my submission that the termination of the tenancy does not take place until the order is actually executed. So the normal contractual position, if I can put it that way, is excluded by statute.
Well, one's got to be a bit careful once you get into that, because there was the recent decision of the Supreme Court on that issue, on appeal from this court.
Well, my lord, yes, I I don't want to, as I said, go into huge detail. I'm simply trying to.
Yeah, to be sure. And I'm not saying it's material for our purposes, but the whole question of the relationship between statute and contract was central to that case. I can't remember the name of the case, but it was a decision of the Supreme Court late last year. And I knew about it because I was on the Constitution of the Court of Appeal. And the Supreme Court arrived at a decision that didn't correspond with either of the submissions of the parties.
My Lord, yes, I think my Lord may be referring to the Katanga
That's the one.
case.
Thank you.
Which was about a very specific type of secure tenancy where there was a fixed term and whether or not there needed to be a contractual provision in the tenancy before it could be terminated during the fixed term.
Yeah, as I say, I don't think it's material for our purposes. I just wanted to sound a note of caution that I was aware that this area was complex.
My Lord, yes, and I entirely accept that it is. The only point I'm seeking to make is that, again, really the point I've been making throughout my submissions on the Act is that the statute has regulated pretty well every aspect of the relationship, including in this particular case, when a tenancy actually comes to an end. So, unlike the position, for example, under the Rent Act, when service of a notice to quit would bring a contractual tenancy to an end, leaving in place the statutory tenancy or the so-called status of irremovability, which required a landlord then to prove grounds or cases before a possession order would be made, but the contractual tenancy was at an end. Here, the tenancy itself does not come to an end by the service of the notice. It simply comes to an end when the order is obtained and executed. Again, and I don't want to, as I say, go on too long about this. Section 82A, page 56. It's not relevant specifically to this case, but relates to a concept called demotion, which is where a landlord can apply effectively for the status of the security of tenure to be removed for a period of time as a sort of cautionary measure in order to try and persuade the occupier to behave in a more reasonable way. And I just draw attention to subsection 3. The effect of a demotion order is to terminate the secure tenancy with effect from the date specified in the order. And if the tenant remains in occupation, it creates a new demoted tenancy with effect from that date. And there are then provisions, which I don't need to take my lord through, about what the terms of that demoted tenancy would be. So again, where one has one of these particular types of tenancy, they can come to an end simply by operation of the statute. When one comes next to section 83 on page 60, this is the first of the notice section. And by subsection A1, this section applies in relation to proceedings for an order mentioned in section 82, various subsections, other than proceedings for possession of a dwelling house under section 84A, absolute ground for possession for antisocial behaviour. So, section 83 itself doesn't apply in a case where there are a claim based on an absolute ground for possession, which is the position in this case. But nonetheless, in cases where that isn't the situation, it goes on to prescribe various requirements for a notice.
And just to be clear, we see in 83 subsection 1, the court shan't entertain proceedings unless the landlord has served a notice. On your case, section 233 would apply there too.
Yes. Yes, I made a mistake in my skeleton argument when I drew a distinction between this statutory scheme and the 1988 Act, and said that the court could dispense with notice under the 1988 Act, but not under this scheme. And my learned friends have pointed that out. They're plainly right. I apologise for that error. It doesn't actually make any difference to my argument, because the only point I was making there was that the 1985 Act and the 1988 Act schemes are not identical. Well, they're not identical in any event, but one of the examples that I attempted to use to show that was an incorrect example, and I apologise for that. But yes, my lord, my case is that Section 233 would apply to any of these notices.
Yeah.
The notice that is relevant in this particular case is at page 65, which is the notice at section 83ZA. And by subsection 1, it applies in relation to proceedings for possession under section 84A, including cases where possession is also sought on a discretionary ground in Schedule 2 of the Act. And by subsection 2, the court must not entertain the proceedings unless the landlord has served on the tenant a notice under this section. And that is the basis, my lord, as my lords will know, on which the district judge granted summary judgment in favour of the respondent, because she held that the notice required by the section had not been served on the tenant because none of the available methods of service had been used. So in this case, where one comes on in section 83ZA to the requirements of the notice and what it must say and the information it must give, there's no issue between the parties as to whether it was compliant. The only matter on which this appeal is based is whether or not it was actually served in a manner that was permissible. And as my lords know, where that comes down to is, was section 233 available to the authority, and if it was, did they act?
Well, I'm not sure that's the limit of the dispute, is it? Because as I understand it, the respondent also argues that even if section 233 of the Local Government Act allowed you to use that particular mechanism of service, it's argued that it's implicit in section 83ZA that the notice must actually have come to the attention of the tenant, given the nature of the requirements of the notice.
Yes. Yes, my lord, that is another further area of dispute. I was, in a sense, parcelling that up with the question of whether section 233 had actually been complied with. But my lord is correct, respectfully. It is a separate question. The provisions of section 83 ZA, so far as they go further than the first two subsections, I don't think I need to go to. I suppose I should say that there is a requirement to notify the tenant of various matters, including that they have at subsection 3C a right under section 85 ZA to request a review of the decision and must tell them of the time within which that request must be made.
And that applies where the notice is given by a local housing authority.
Yes.
I mean, obviously, there would be other circumstances. Well, I assume there are still other circumstances in which such a notice won't be given by a local housing authority. Or is that not the case now that you've excluded so many people from the definition of secure tenancy?
This kind of notice is only served on secure tenants where the authority is seeking what's called an absolute ground for possession. In other words, where if the court finds the ground made out, it has no jurisdiction to consider whether it would be reasonable to make a possession order, which would be the normal power that it would have under the secure tenancy regime. So Parliament has said that in relation to certain grounds, they're referred to as absolute grounds. In other contexts, they've been referred to as mandatory grounds. But they only apply where the tenancy is secure. Tenancy is not secure, then
It really doesn't matter, but just so I get it clear in my own mind, you've explained that an awful lot of people are taken out of the landlord condition now, or at least housing associations are. Is it still the case that the landlord of a secure tenancy who is seeking to invoke Section 84A won't necessarily be someone in respect of whom the review mechanism under Section 85 ZA applies?
sorry,
Yes, sorry.
Lord, I was just handed a note by my learned friend, and I missed my lord's the last part of my lord's question.
The review mechanism only applies where the landlord is a local housing authority or a housing action trust. And I think you say housing action trusts have fallen out of the picture, really. At least historically, the landlord of a secure tenancy needn't have been either of those things.
They would always have to have been within whatever bodies were specified by Section 80 at the given point in time.
And is it still the case, and I really don't think this matters despite my making a thing of it, is it still the case that the landlord of a secure tenancy seeking to invoke Section 84A won't necessarily be a body such as is referred to in Section 85 ZA, namely a local authority or a housing action trust?
They the provisions of Section 85 ZA limits the right to seek a review to landlords who are local housing authorities or housing action trusts. To the extent that Section 80 also specifies other public bodies who can grant secure tenancies, such as a development corporation, a mayoral development corporation, and in some cases the Greater London Authority, and various other bodies of minor importance in the context of the provision of public housing. Section 85 ZA does not refer to a right to seek a review. It's also the case that under the equivalent provisions in the Housing Act 1988, where, for example, a housing association having granted an assured tenancy seeks possession on one of these absolute grounds, there is no equivalent right to seek a review. So the review power is narrower, in my submission at any rate, than either the regime for absolute possession orders that has been applied to social housing as a whole, and is in fact also narrower than the bodies that can grant secure tenancies.
Yep.
My Lord, Section 84A on page 74 sets out the absolute ground for possession for antisocial behaviour. Court, by subsection 1, has to be satisfied that any of the following conditions is met, but if it is, then it must make an order for the possession of the dwelling. So, if a notice hasn't been served, it can't entertain the proceedings. If it can entertain the proceedings and is satisfied that one of the conditions in Section 84A is made out, it must make a possession order, subject to convention, defence, within the meaning of the Human Rights Act, and again, it only applies if the landlord has carried out a review that has been requested by subsection 2. So the procedural requirements have to be complied with. But if they are, and the court is satisfied that the person has been engaging in conduct that falls within one of the conditions, then it must make an order for possession. The condition in the present case is relied on was, in fact, condition 1, which related to conviction for serious offences. My Lord, we've looked briefly at Section 85ZA on page 81. I don't think I need to ask my Lord to go back to that. The review, if requested, must be carried out and the result must be notified with reasons if the decision is to proceed with possession proceeding. So, my Lord, that essentially is the scheme of the Act of 1985. And as I've said, it's the Council's case that this is plainly a highly regulated statutory scheme, which involves, in certain circumstances, the statute requiring certain notices to be served. My Lords also have in the bundle the scheme of the Housing Act 1988. I don't want to go to it in any detail. I understand my learned friends will be making submissions about it. But what I would simply go to, if I may, is section 1 on page 86. Which sets out what is an assured tenancy. And as my Lords will see from subsection 1A, B and C, the conditions are less restrictive because although it requires the tenants to be individuals and one of them to occupy as their only or principal home. The landlord condition that my lords have seen in the 1985 Act at Section 80 is not here in the same way. Now, that does not mean that there are not certain types of tenancy that can't be assured. And in Schedule 1 to the Act, which begins at page 105 of the bundle, I haven't put all of the types of tenancy that can't be assured in, but on page 106, paragraph 12, my lords will see the heading Local Authority Tenancies, and by Schedule 12, paragraph 12 of Schedule 1, a tenancy under which the interest of the landlord belongs to a local authority as defined in subsection 2 is one of the tenancies that can't be assured, and it includes new towns, urban development corporations. My lord will recall the sorts of bodies that were included in Section 80 as those who could grant secure tenancies. Here, they can't grant assured tenancies. And by subsection 2A, the council of a district is a local authority for these purposes. So, the schemes of the 1985 and 88
by subsection 2A, did you say?
Sorry, subparagraph 2A
I see, yes.
on page 106.
Yep. Yes.
So the schemes of the 1985 and 88 Act work in tandem. The 1985 Act prescribes who can grant secure tenancies. The 1988 Act effectively says that anybody can, any type of landlord other than those excluded can grant an assured tenancy, and that's why the assured tenancy regime is so much more widely available to both private landlords and most social landlords who are not local authorities. My submission is that the 1988 Act regime is not particularly relevant because it doesn't apply to local authorities, and Section 233, whatever it may apply to within the sphere of local authorities, has no application in relation to the 1988 Act. Now, the judge below, and my learned friends say, well, that's significant because it means that there might be equivalent landlords who don't have the ability to serve in the way that Section 233 prescribes. And I accept that that is the case as a matter of law. Section 233 does not apply to them, but for the reasons that I will develop shortly, if I may, my submission is that that's not a basis on which the court below should have held that Section 233 was unavailable in this case. My lord, I'm not going to take the court to Part 5 of the Antisocial Behaviour Crime and Policing Act unless it would be of assistance. Again, I think it's an authority, it's a statute that my learned friends wanted to be in, I think, in order to say that there was an equivalence between the absolute grounds for possession available to a local authority and those available to other types of landlords. I accept there is an equivalence, but they're not the same. So, my lord, then I need to come on to the Enfield and Devonish case, if I may, which is at tab 6, page 146 of the bundle. Because that was the basis in my submission of the judges below accepting the argument that Section 233 could have no application to a notice served by a local authority in the present case. And my lords, my submission is that the Devonish case doesn't actually say that, to the extent that it may have given the court below that impression, that was respectfully as a result of a misunderstanding about what the Court of Appeal in that case was saying. But that in any event, if there were wider points being made by Lord Justice Kennedy in that case as to the use of Section 233, those comments were obitted in any event. But I'll come to those. It's a short case, so I'll come to them quickly. My Lord will see from the introduction to the headnote that was a case about a notice to quit. Paragraph 4 sets out Section 196 of the Law of Property Act 1925, which was the relevant provision of statute that was relied on in that case. And my Lords will see from from page 147 that tenancy had been granted to the first defendant's mother, which could be terminated by 4 weeks' notice to quit. Then, pausing there, in 1980, the Housing Act 1980 introduced security of tenure for local authority tenants, and that was continued in the 1985 Housing Act, as we've seen. When the first defendant's mother died, and the first defendant succeeded to the tenancy, he lived there with the second defendant. Then the authority got a possession order against the first defendant on rent arrears grounds. And there was an agreement not to enforce if the arrears were paid off. In 1994, the authority discovered the first defendant wasn't living there. The second defendant remained. The authority were unaware of the first defendant's whereabouts and left a notice to quit addressed to him at the property. Because in 1994, when the defendant who had succeeded to the tenancy and had thereby become the tenant had left, he was no longer satisfying the tenant condition under Section 81 because he wasn't occupying the property as his only or principal home. So the tenancy would no longer have been secure on this analysis and could be terminated by notice to quit rather than by a statutory notice under the Housing Act itself. Subsequently, they issued possession proceedings against both defendants. Common ground that the agreement following the possession order had been the grant of a new tenancy. The judge made an order for possession and held that the Law of Property Act, Section 196, and the Local Government Act, Section 253, applied to the service of the notice to quit, and accordingly it had been properly served. And the matter then came on appeal to this court. The relevant holding in relation to this statute is the fourth holding. The provisions of Section 233 apply to notices required to be or authorised to be given by or under any enactment. They do not apply to the service of a notice to quit, which is required to be given by the common law. So the question of Section 196 of the Law of Property Act was also dealt with, but it's not relevant to this appeal. It's only the fourth holding that's relevant to this appeal. And the relevant passage from Lord Justice Kennedy's judgment, he comes on to deal with Section 250 at the bottom of page 152 of the bundle, not of the report, where he sets it out. And then, on page 153, there's an important passage just below the end of the citation of the statute, beginning Mr. Maguire for the Council, points out that when the agent of the Council purported to serve the notice to quit, that was something which the Council, as a local authority, was empowered to do by Section 111 of the 1972 Act, which, so far as relevant, provides that a local authority shall have power to do anything which is calculated to facilitate or is conducive or incidental to the discharge of any of their functions. One of the functions of a local authority is, of course, to manage its housing stock. Mr. Guire points out that in Atwell no reference was made to this section, and had it been drawn to the court's attention, the court would have reached a different conclusion. So, pausing there, in my submission what was being argued was that although the notice in question in that case was a common law notice to quit, it effectively became a notice authorised to be served under an enactment because the local authority as a statutory body had to have statutory powers in order to serve it. And that was why the reference was made to section 111, the incidental power, because it was said that that conferred a power making the service of a common law notice within section 233. And the court, in my submission, not unsurprisingly held, immediately below where I stopped reading, in my judgment, section 233 cannot assist the council in this case because the notice to quit was not required or authorised to be given by or under an enactment. It was required to be given at common law by the landlord if the tenancy was to be determined. And it's of no consequence that because the council happens to be a local authority, they are therefore a creature of statute authorised by statute to act inter alia as landlords. We then come on to the passage that the judge considered important below and that the learned friends rely on. Many statutes and statutory instruments do specifically require or authorise a local authority or one of its officers to give some form of notice. And in my judgment, section 233 is intended to assist local authorities to give notice in such cases, but not to relieve a local authority of obligations which fall on every other landlord, including, for example, a housing association. Indeed, if the council's arguments are right, they could place a local authority in an advantageous position in relation to many ordinary commercial activities undertaken by local authorities, such as exercising an option to purchase or issuing a certificate in relation to a building contract. I find it difficult to believe that section 233 was ever intended to have such a wide-ranging effect. I do not wish to attach too much weight to textual criticism, but if the intention were as wide as Mr. Maguire suggests, I can see no reason for including the words by or under in any enactment in section 233 subsection 1. Mr. Maguire submits those words do exclude, for example, building contract certificates. But if his principal argument be right, I do not see why there should be that exclusion. My Lord, in my submission, the examples given by Lord Justice Kennedy in that part of his judgment are instructive. He refers, for example, that if the authority's arguments were right, it would affect exercising an option to purchase or issuing a certificate in relation to a building contract. Two matters in my submission, which in general terms have nothing to do with a requirement of an act, but are simply normal operations undertaken contractually, which, if the argument on section 111 were correct, would be turned into statutory notices as a result of the status of the authority as a statutory body requiring statutory authority. And that's why in my submission, His Lordship said at the end of that paragraph, if the argument were correct, there's no reason for having included the words by or under any enactment. In my submission, it's clear, respectfully, that Lord Justice Kennedy was still dealing with the argument being raised before the court that would have, in his judgment, had the effect of turning any old notice, however it was caused to be served, whatever the basis for it being served, into a statutory notice simply because it was served by a local authority. And the court, in my submission, rejected that argument, but only that argument, because it's quite clear also from that paragraph, from the passage beginning, many statutes and statutory instruments do specifically require or authorise a local authority or one of its officers to give some form of notice. And in my judgment, section 233 is intended to assist local authorities to give notice in such cases. Now, my starting point in this case is that the Housing Act 1985 is just one such statute. It requires local authorities, if they wish to take certain forms of legal action, to serve specific notices, and it specifically includes that requirement. Even if it could be argued that the local authority doesn't have to take possession proceedings, the legislation in my submission plainly authorises them to serve such notices. I drew attention at the very beginning of my submission in relation to section 233 itself of the breadth of the language in section 233 subsection 1, and in particular the words that the provisions of the section have effect in relation to any notice, order or other document required or authorised by or under any enactment to be given to or served on any person by or on behalf of a local authority or by an officer of the authority. My Lords, while I entirely accept that that language is not apt to turn a normal common law or contractual notice into a statutory notice, simply because the body serving it is a statutory body, I do say that Parliament has clearly intended local authorities to have the powers conferred by section 233 in relation to any notice required or authorised to be served by or under any enactment, and that statutory language should not be cut down in the case of a statutory notice.
I mean, as you say, on your case, this has general application.
Yes.
We're focusing on it in a very particular statutory context. But on your argument, actually, it must go a good deal wider. I don't know whether you've thought about where else it would apply. I was trying to think about it, for example, before you present a bankruptcy petition, or potentially before you present a winding up petition, you either have to or may wish to serve a statutory demand. It would apply there, presumably. Yeah, I mean, you obviously haven't got the provisions in front of you, but as a matter of general approach.
My Lord, as a matter of general approach, I have to submit that if a statute requires a local authority to serve a particular document or a particular notice or order, then that is within section 233. I suppose.
Well, you go further still, because
sorry, my Lord.
you go further still than that, because it not just requires, it also, if the statute authorises.
Yes. Now, I can see that there could be a difference in, for example, like a statutory demand, where that is a statutory notice that is not. Wondering whether I do accept this.
I mean, the one difference, of course, is in the case of a statutory demand, it doesn't say anything about local authorities. It just says creditor.
Yes.
One type of creditor is a local authority. But then, equally, the Housing Act provisions don't say local authority, albeit that the landlord will normally be a local authority.
Well, that was the issue I was thinking about
Yes.
in response to my Lord's point. I mean, plainly a statutory demand is something that anybody who is in the position of a creditor would have to serve. I don't think I need to go as far as that in this case, because even if it is the case, which it clearly is, that a local authority is not the only landlord under Part 4 of the Housing Act 1985 that might be in a position of serving a Section 83 ZA a notice. Nonetheless, as I tried to show from my quick-ish romp through the provisions of Part 1 and 2 of the same Act, the specific requirements and the specific statutory scheme imposed on local authorities in relation to housing, public housing, housing that essentially comprises secure tenancies, is unique to local authorities. They have a specific statutory role in Parts 1 and 2 of the 85 Act. They have specific duties to the homeless, Part 7 of the Housing Act 1986. The way they allocate their properties is regulated by Part 6 of the Housing Act 1986. So, if one simply took Section 83ZA out of its context and said, well, it's not just a local authority that might serve these notices. It's true that it is not just a local authority, but the position of a local authority in relation to the provision and the management of its housing stock is regulated in a way that is not the case for all other bodies that provide housing. It's regulated in a very different way for housing associations.
So to speak, we see in the 1985 Act who the landlord can be
Yes.
for the purposes of a secure tenancy. And then we see in Section 83 ZA something about the landlord serving a notice. Theoretically, Parliament could, at the stage of referring to the landlord, have spelt out all the possible landlords, and then you would say, well, it's obvious that the statute is referring to a local authority serving a notice. You say, well, if they use the shorthand instead of specifying the possible landlords and then referring to landlord, the result is the same.
My lord, yes, my lord, the statutory drafting technique that's used throughout Part 4 is to refer to the landlord and tenant. And in my submission, there's no particular conclusions that can be drawn about that. My submission is that what is the critical piece of legislation is the Local Government Act 1972, rather than this legislation which was introduced many years later and has been repeatedly amended for its entire time on the statute book. Even in relation to Section 83 ZA notices, the position is not the same for all landlords serving those notices, as my lord has pointed out to me this morning, that the requirement that the notice must inform tenant of any right that the tenant may have under Section 85 ZA to request a review is only applicable to local authorities and under Section 85 ZA Housing Action Trusts, which there currently aren't any. But this is a very narrow category of landlords who would be serving a notice under Section 83 ZA that informed the tenant of a right to request a review. So that Section 83 ZA notice would not be the same as a Section 83 ZA notice served even by any of the other landlords within Section 80.
Yeah.
And whether or not it's an operative difference between this sort of notice and, for example, a statutory plainly a matter for my lord. But in my respectful submission, there is a considerable difference. Even if my lord is not with me on the broadest interpretation of my case, which would mean that it's difficult to see, in my respectful submission, why Parliament, which was plainly legislating to give local authorities a more favourable regime for service in relation to notices and other documents required or authorised by enactments, why Parliament should be construed as having the intention of not meaning that the words it used should have the broad effect that on their natural language they do, but should instead be given some narrower meaning, which can't be derived from the language of section 2331. Devonish suggests an approach, but in my submission it was an entirely different context, because that was a case in which a local authority was seeking, I would submit, to broaden the application of section 2331 beyond even the wide words of the section. And this court, with respect, held that that wasn't what the section meant, and I don't quibble with Devonish, and I don't contest that that was the right result. But what I do say about Devonish is that to the extent that one looks at the words of Lord Justice Kennedy on page 153 in the second half of that long paragraph in the middle of the page, it is quite dangerous to take those words out of the immediate context of the judgment where he was, and out of the context of the argument his lordship was dealing with, and say, oh well, there we are, because he says it was not the intention to assist an authority to have an advantageous position in relation to other sorts of commercial activities, or because it wasn't intended to relieve the authority of obligations which fall on every other landlord, then that means that one is in fact narrowing the language of the section as distinct from a refusal by the court to expand the language of the section. The notice in this particular case, in my submission, cannot properly be described as an obligation which falls on every other landlord, such as it was appropriate to describe a contractual or common law notice to quit, which simply does apply in any case where there is a tenancy, save where statute has excluded it. So, in my submission, there is a very big difference there. My Lord, the only other case that we have found, I think, between us, that even considers Devonish is the Southwark Akhtar case at tab 7, page 155. And even there it is dealt with as an upper tribunal decision. Her Honour Judge Elizabeth Cook, sitting as a deputy judge of the upper tribunal, on page 167. And this was a case that related to the service of service charge notices. I don't want to take my lords through all of it because it really doesn't.
Well, isn't it just a sideline bit?
Well, it is. But can I just point to paragraph 71 above that, where the judge found that Section 196 of the 1925 Law of Property Act applied to the notices with Section 7 of the Interpretation Act. So, in my submission, that really dealt with the issue in the substance of the case. The argument as to Section 233 is only dealt with at the bottom of 71 briefly. The other three are dealt with briefly, and Section 233 is dealt with in the next three paragraphs. In particular, the judge simply endorses the Devonish and endorses the approach to Devonish, which I think my learned friends would ask the court to adopt in the present case, in my submission. Again, whether or not in the context of service charges, the substantive conclusion that Section 233 shouldn't apply is not something that I need to go into. I'm not going to ask the court to rule on.
But the reasoning begs the question, doesn't it? Because she says only where enactment requires or authorises service by a local authority in its capacity as a local authority.
Yes.
But as you've pointed out, one of the things that local authorities do is provide housing, and in particular secure tenancies.
Lord, yes. My Lord, yes. My submission is that this case doesn't really take matters any further. I refer it to the court simply.
Yep.
Because it's there.
Thank you.
My Lord, in many ways, those are my submissions on Section 233. I'm not sure that there's much more that I can say about it.
No, thank you.
Can I come on briefly then to the question raised by the respondent's notice, questions raised by the respondent's notice, which are whether or not
This hearing is listed or was listed for half a day.
my Lord, yes, I won't be more than 10 or 15 minutes.
Okay, thank you. I'm not saying we have to absolutely, but bear that in mind.
My Lord, yes. My Lord, yes, I hadn't intended to take quite so long, but I will be quick. The points are whether or not it is necessary to prove receipt, even if Section 233 is engaged, and whether or not, if Section 233 applies, the authority complied with the requirements so as to be able to rely on it. My Lord, really the points I wish to make are within the two additional authorities that I handed up. In the first of those, Boora and Jones, which related to a notice under the Agricultural Holdings Act that was shoved under the door of the agricultural tenant. And the tenant said it had not only gone under the door, but had gone under the lino that was inside the door, so that it wasn't until many months later, when replacing the lino, that they'd found the notice. And therefore the question was, had it been properly served? And the holding at page 190 of the new edition to the bundle
Yes.
was that to serve a notice by leaving it at the proper address of the person to be served, it must be left there in a manner which a reasonable person minded to bring the notice to the attention of the person who it was addressed would adopt, and in the present case the landlord in putting the notice under the door had adopted such a manner. And it's really the passage beginning at 194 above F, Lord Justice Russell, where he says that, but then he adds at the end, that is to my mind the only qualification or gloss, if you please, proper to be placed on the express language of the statutory provision. I suppose I should just point to page 193F, where the relevant statutory provision is set out. Any notice under this Act shall be duly given to or served on the person to or on whom it is to be given or served if it is delivered to him or left at his proper address or sent to him by post in a registered letter. So although not exactly the same wording as section 233, for the purposes of leaving it at his proper address, in my submission it is substantively identical. And in my submission, this court held that there's no specific means of leaving a notice at someone's address that has to be used in order to fall within those words. What the only gloss it's appropriate to give to the statute is that it must be served in a manner in which a reasonable person would serve it. My Lord, we have the witness statement of P.C. Reynolds in this case, which was attached to my application. Where he says in the third paragraph down, on attending the address, I knocked on the door and a female answered the door. She stated she was the partner of Mr. Bravington and accepted the letter on asking her name.
Was this a factual issue that was explored below, or not, because of the way the case went?
Well, it was never explored as to whether the police officer was telling the truth, as it were. The witness statement was before the courts below, and the courts below took the view that handing it to the partner of Mr. Bravington did not fall within any of the common law means of service available, because they held that it was impossible that if the matter went to trial, the council would be able to show that he'd received it. And because section 233 was held not to be applicable,
Yes.
it didn't matter.
But was the manner in which it was said to have been served disputed, or?
Well, the district judge, in giving judgment, said that there were some disputes as to some aspects. There was, in P.C. Reynolds' statement, he later says that on a subsequent police raid on the property, they'd found the letter opened in a kitchen drawer, and there was a dispute as to whether that evidence would have been admissible at trial, because whether or not the raid was a lawful raid and that sort of thing. I don't understand it to have been in dispute.
Sorry, I don't quite understand that point. I mean, the ordinary rule is that evidence is admissible even if unlawfully obtained, although in some contexts courts have powers to exclude such evidence, but the default is unlawful obtaining is no bar to admission.
My Lord, yes. Well, my Lord, the only relevant passage I can find in the district judge's judgment is at paragraph 11 on page 92, where she says that the claimant's position is that the notice has been correctly served.
Right.
She refers to the witness statement. She refers to some video evidence which was not viewed during the hearing. It was said by the parties to show police officers conducting a search of the property and showing there were papers in the drawer, including the notice.
So perhaps to what if your contention is accepted? What do you say that this court should do?
My contention in relation to service, or
Yes.
what I say the court should do is...
In respect of section 233.
I say the court should allow the appeal in the sense of allowing the case to go to trial.
Right.
So that summary judgment would be
Set aside.
set aside.
And so issues as to how it had been served could then be explored at a subsequent hearing.
My lord, yes.
Right.
Can I ask you two supplemental things?
My lord.
First of all, I see in your skeleton that you record that Mr. Bravington and his girlfriend had, during the course of the proceedings, initially denied that the notice had been handed to her, only admitting that fact when faced with video evidence. I mean, I saw in the defence the averment that Mr. Bravington had been told by his girlfriend that she hadn't received it. That was abandoned as a contention, was it?
My understanding is that it was. I didn't do the hearing in front of the district judge. But my recollection, I don't know if will correct me if I'm wrong, my recollection by the time the matter became subject to the appeal to Judge Boora, it was no longer disputed that she had in fact received it.
But on the other hand, all those issues, I mean, because you're saying you understand that you're simply saying that the summary judgment should be set aside,
yeah.
that we determine the legal issue as to the effect of section, whether section 233 applies, and certainly the first point in the respondent's notice, whether it's necessary to approve receipt, but the second issue, whether actually section 233 was the evidential issue, one might call it, would need to be determined at a subsequent hearing below.
My lord, yes.
Yes?
All I'm saying at this stage is that there was plainly evidence, and there is plainly evidence of
I
service.
understand that, but yes.
And I would submit that it was a reasonable method of leaving it at the property.
But that's not an issue that we have to determine,
Well,
because we're not in a position to determine it,
no.
because it requires findings.
My lord, yes. The question it relates to is the question raised in the respondent's notice, whether the appellant actually employed a method.
I understand that.
I accept what my lord says, and I would respectfully.
I mean, technically that might not arise, but if we were able to determine it, it would be silly not to determine it, because otherwise it might arise on a subsequent rehearing.
Yes.
Someone might say, well, hold on, what does this mean? Does it mean you have to prove receipt or not?
Yes.
Yeah.
My lord, in respect of having to prove receipt.
Just before you do, can I ask my second question?
Sorry.
If you go back to the district judge's judgment,
Yes.
paragraph 25. She says there, the claimant does not rely on having served the defendant by leaving the notice at the property. Now, on the face of it, that's inconsistent with what you're saying. What I don't quite understand is how it fits in with reliance on section 233, because the reliance on section 233 presumably only made sense if you were alleging that the notice had been left at the property.
My lord, yes. I don't know what that paragraph means. I wonder whether she means that in the particulars of claim, it's not said that it was left at the property. The certificate of service says that it was handed to Shazana Ellis, girlfriend of E. Bravington. And it may be that she is referring on page 113 to the fact that that box was ticked by the police officer, Mr. Brooke, rather than the box that says,
Yes, I see.
by leaving it at a permitted place. I suspect that is what she may have been referring to.
So it's in that context you would say that the witness statement might add something, because it tells you it's at the property.
Yeah.
Yeah.
My Lord, just finally then, moving on to the second point raised by the respondent's notice, it's my submission that the point of section 233 is not to require that when, for example, a document is left at property, the claimant must also be able to show that it came to the attention of the individual on whom it was meant to be served. And I've handed up the case of Rushmore and Reynolds, decision of the Divisional Court in page 197. And this was a notice under section 16 of the Local Government Miscellaneous Provisions Act, which is simply a notice asking for information about who lives at a property and who has an interest in that property. It's a notice that is available under that act. I suppose I might say in relation to my general point on this appeal that any landlord could put in a tenancy agreement or lease a requirement to supply information if it's requested in a particular notice. This was a statutory notice under the Act, and the particular recipient, who was the defendant, as we see on page 199, in the sideline, the first sideline paragraph, the recipient said they didn't receive it at all, and for the appellant it was submitted the notice had been served, having regard to the provisions of section 233. The information, in other words, the prosecution in the magistrate's court failing to comply with it, was therefore, the information had been properly requested but not furnished. There was an offence of strict liability, so the court had no discretion but to convict. Whether or not the respondent had actually received and was aware of the content of the notice was a matter solely of mitigation. No authorities were referred to. The respondent himself maintained he did not receive the notice and could not read or write. In this case, the justices held that there was an onus of proof to satisfy the court that the recipient had not received it on the balance of probabilities, and they dismissed the information on the basis that they thought it was more. They couldn't conclude that it had come to his attention. The bottom of that page. If the council's arguments are validly made, we must answer question 1 in such a way as to make questions 2 or 3 material. Question 1 being, was there any such requirement? And then at the bottom of page 200, Mr. Stone correctly contends that the only matter which could be contested, as is clear from section 7 of the Interpretation Act by the respondent in this case, had the notice been sent by post, was the time at which the document was actually delivered. Otherwise, he asserts that whether the method chosen was sending it by post or causing a servant or agent to deliver it through the letterbox, the presumption is the same by dint of section 233 and section 7, namely that service has been effected and cannot be denied. In other words, it's an irrebuttable presumption that nothing can be said to the contrary. I agree with that, and so would allow this appeal.
But pausing there, that seems very odd reasoning, because what it's saying is that even though section 7 is on its face inapplicable because we're not dealing with service by post,
Yes.
nevertheless you interpret section 233 in the same way, even though that's not what section 233 says either.
Well, my lord, I may have taken it too quickly, but I think the point that was being made is that service by post is one of the methods permitted by section 233. Section 7 would be applicable potentially in that situation. And therefore its effect is potentially relevant to the
But how does that stack up? Go back to section 233. And as you pointed out to us earlier, subsection 4 says, for the purposes of this section and of section 26 of the 1889 Act, so we now read section 7 of the 1978
yeah.
Act, service of documents by post, in its application to this section, proper address is. So the 1972 Act is expressly cross-referring to the Interpretation Act,
Yes.
but it only insofar as it's service by post. So it can't be saying, surely, that the same deeming applies where it's not service by post.
Well, my lord, I don't particularly rely on section 7 in relation to my argument particularly. This is the reasoning of the divisional court in that case. But the critical point in my submission is that the court concluded that service under section 233 did not require proof of receipt. Once the method of service has been complied with, then by the wording of the section itself, service has been given. And it also relied on the Lambeth and Mullins case that's referred to at the bottom of that page, where it was held that insertion of an abatement notice through the letterbox was capable of constituting service.
But the difference may lie in the question of whether it's rebuttable or irrebuttable.
Yes.
Because what Lord Justice Watkins says is that in the case with which he's dealing, it's an irrebuttable presumption, but that doesn't necessarily come out of Lambeth and Mullins, does it? Because what's quoted from Lord Justice Wolfe is the statement, the local authority therefore correct in submitting the service of the notice by insertion through the letterbox complies with those requirements. Well, indeed so. But that doesn't necessarily create an irrebuttable presumption as opposed to a rebuttable one, does it?
It doesn't necessarily, my lord. That was the way. I considered that the Rushmore case was more helpful than the Mullins case because it actually addressed the point directly.
To be sure. I think you're right about that.
The Mullins case, in my view, having looked at it, didn't address the point directly. So, to that extent, that's why I brought Rushmore rather than Mullins. But what I would say is that the court considered that compliance with the requirements of section 2332 amounted to service under section 233. In many ways, whether or not the presumption is irrebuttable or rebuttable is not something that necessarily needs to be resolved on this appeal for the reasons that my Lord Justice Moylan discussed with me a moment ago in relation to the other matter arising.
Well, can I question that? Because if your reliance upon this authority is sound, bearing in mind it's not binding upon us, then what this shows is that if you comply with the mechanisms specified in section 233, then it's irrebuttable. And if that's right, then there's nothing factual to investigate.
Well, my lord, no. Well, yes, I accept that. And it is my submission that compliance with the statutory mechanism is sufficient. And it's my submission that there are indications from that in the language of section 233 itself. So, for example, if it had been intended that there were room for the recipient to argue that they hadn't received it, one might expect some language in relation to, unless the contrary be shown. Similarly, if one looks at subsection 7, if you can't find out the name or address of the person who needs to be served after reasonable inquiry, you can leave it conspicuously affixed to the land or hand it to someone who appears to be resident or employed on the land. Now,
Well, I would understand that point if it wasn't for subsection 4, because section 4 expressly cross-refers to the Interpretation Act, which creates a deeming provision, but only for service by post.
yes, but what subsection 4 says is in relation to what is to be considered the proper address of the person. For the purposes of this section and section 126, the proper address of any person to or on whom a document is to be given shall be his last known address. So my reading of that, respectfully, is that it's not saying section 7 is incorporated into section 233 for post. It's saying that where in relation to both of those sections, the question of what is the person's proper address arises, and whether it was served on the proper address, these are the addresses that are to be considered the proper address in the categories of case that are set out. So it's last known address unless it's a corporate body or a partnership.
Can I ask a question about the relationship between subsection 4 and subsection 7?
Oh, yes.
Subsection 7 says if you don't know the address, you do a certain thing.
Yeah.
Where you know a last known address, does that mean you don't need to do the subsection 7 step? It's enough just to leave it at the last known address.
My submission in relation to this is that subsection 7 is primarily aimed at cases where trespassers have come on land and you don't know who they are or where they normally live.
Yeah. So you don't have a last known address.
You may well not have a last known address.
So where you do have a last known address, even where you know full well that the person has emigrated to Australia, you say you can leave a document under this provision at that last known address. The person in Australia, doubtless, could very often on the facts rebut any presumption. Say, well, I was in Australia. Then the local authority would be in difficulties, I suppose. There would be no mechanism for achieving service.
Well, my lord, yes. My lord, in my submission, there are 2 points. One is a broader point, which is that my submission is the purpose of this, to allow service to take place by leaving it at an address, even where they may have emigrated to Australia, because local authorities performing their functions should be entitled to not have those functions frustrated, if I can put it that way. Of course, in the case of a tenancy which hasn't been terminated, in my submission, it's no hardship for the tenant to be served at the address of the tenancy, because until the tenancy is terminated, they still have obligations.
Just jumping round and without having got the facts at my fingertips. I mean, if you compare again with the corporate context,
Yes.
there's a statutory provision, isn't there, saying that you can serve a company at its registered office.
Yes.
Now, I don't think there's any question there of the company being able to come back and say, well, actually, we no longer had any presence at the registered office. This document never came to our attention.
No.
Yeah.
So, my lord,
So just picking up on that point, do I understand, coming back to our discussion earlier, that what you say about Section 7 is that it's about timing?
well, yes.
At the time at which the letter would have been delivered. So what you can prove is it came late.
Yes. Of course, if it's left at the property, then it's left when it's left.
Yeah.
Thank you.
My lord, in view of the time, may I just have a moment? Unless that can be a further.
Thank you very much. Yes, Mr. Travel.
My lord, plainly the central issue is whether or not Section 233 is available at all. We submit that it's not, and I want to take your lordships to a slightly wider view of how 233 fits into the scheme of the 1972 Act, and just a word or two about its legislative history. Because we've been discussing 233 as if it were a general mechanism for service, or were potentially a general mechanism for service by local authorities. It's not my submission, the obvious reading of its place in the scheme of local government legislation. But can I start by just defining the issue about 233 as tightly as I can? And in my submission, the issue can be closely defined by reference to Lord Justice Snowden's grant of permission on this ground, which your lordships will find at pages 23. I'm looking at your
Yes.
it's page 22 of,
Yes.
of the bundle.
Yes.
The grant of permission on ground 1, I may need to say a word or two about the terms in which ground 2 is discussed somewhat later in my submissions. But the terms on which ground 1 is submitted is Lord Justice Snowden says the question of whether Section 233 should be read as only applying where a statute requires or authorises service of a notice by a local authority acting in its capacity as such, but whether it applies where a statute authorises or requires service, but it is by a party, and that party happens to be a local authority, is not expressly covered by the decision in Enfield and Devonish, short and important point, and so on. So in my submission, critical issue on 233 can be expressed on the basis of it's the task of the court to establish whether the local authority in serving the notice is acting as a local authority as such, acting qua local authority.
But I don't understand the distinction you're attempting to draw, because one of the core functions of a local authority is to provide housing.
Yes,
So
indeed.
why is it not acting as a local authority?
Because there are, as Lord Justice Kennedy says in Devonish, it's a commonplace of the scheme of local government law that there are a range of notices which the local authority as a public body, notices which the local authority as a public body is going to serve. So the classic examples are, for example, a liability order in rating. The local authority is the rating authority.
But let's suppose it was building a road.
Yes.
And a notice was required. Maybe it's compulsory purchase prior to building the road, whatever it might be. But building a road is a core function of local authorities as well. And why is that not equally covered by Section 233?
Compulsory purchase, I hadn't actually thought about compulsory purchase, but compulsory purchase might be an example where it's the local authority as the purchasing authority which does serve the notice. If it has to deal with, say, a party wall, let's take another example of a statutory scheme, then the statutory scheme about party wall notices. The local authority, just like anybody else, will have to serve a party wall notice if it wishes to invoke the provisions of the statute. That doesn't mean it's pursuing one of its functions. That was the gist of the very broad submission made in Defendant. Pursuing one of its functions, but it's not serving a notice in the form envisaged by the wording of 233, which I'll come to. The key in to this case is in the wording of 233 and then read together with the notice provisions within the Housing Act.
Okay, we're taking you out of your course.
No, not at
it's
all.
probably a bad idea, but just coming back to the compulsory purchase and showing my ignorance of the relevant law, would we find in the compulsory purchase legislation a power which could be exercised either by a local authority or, say, by the Secretary of State? Would you find in the legislation such
You
a
certainly
power?
find both of them able to compulsorily purchase.
And would one find
exercising the same power and slightly reluctant to answer that.
Yes, I see. I mean, just suppose for the sake of argument that you find somewhere in the legislation a power compulsorily to purchase, and it says it can be exercised either by a local authority or by the Secretary of State. On your case, if the local authority exercises that power, is it doing so qua local authority?
Well, I think the answer to that question is yes, but I would want to perform the exercise which I'm just about to perform.
Yes.
And to fit together with the thought that you, the local authority, might be acting qua local authority. Say, for example, you're the rating authority and you serve a liability order. Or you might be acting in a position where the local authority wishes to pursue its statutory objectives, it makes use of a machinery which is more widely available, for example, a party wall notice. Now, in the first case, you are acting as local authority, of my case. I fully accept there are going to be some questions of investigation for the court. I'll come back to the practicalities in about a minute of the exercise the court might be asked to carry out if my learned friend's case is accepted. But there may be some issues to investigate. But if you're dealing with liability orders, or you're dealing with enforcement notices in the planning field, they're issued by the local planning authority. No one else issues, certainly a state may be able to issue them, to answer the question that's been put to me about the parallel with compulsory purchase. But the local planning authority, as local planning authority, has a power to issue a notice to enforce planning law. On the practicalities, I'll show your lordships in fairly shortly the legislative history of 233. If one carries out, as I have done, a Westlaw search on the references to 233 to see the range of cases in which there's been some debate about its applicability or otherwise, the first thing is that there's strikingly few of them. But the second thing is that none of them relate to situations other than the classic liability order planning enforcement cases. They all have that sort of statutory regime flavour. So on the practicalities, what my learned friend is urging your lordships to do is to insert into general local government law a wide-ranging ability to serve in the manner prescribed by 233, which no one apart from Mr. Maguire in Devonshire should realise could be argued existed, and which is certainly not being widely used at the moment, unless Moylan and Friends appeal succeeds in this case.
And where would it be? I touched on this with Mr. Manning. Where would this question be relevant, apart from the landlord and tenant context?
Well, it would be relevant. I mean, well, my learner friends, I think my learner friend accepted and then somewhat drew back from the proposition that on your lordship's example of a precursor to a bankruptcy petition, the relevant notice would be served by a local authority under a statutory regime. My porting wall example, and accordingly, 233 would suddenly be being inserted into the bankruptcy regime in a way in which I hope to persuade your lordship is pretty clear wasn't originally intended, and which, on my submission, the correct reading of Lord Justice Kennedy and Devonshire is to that effect. So on the practicalities, we say that the local authority and subsequently the court, in deciding on the availability of section 233, has an exercise which it's quite difficult to really tightly define, but nonetheless is within a narrow compass, decide whether or not, under this regime, the local authority in serving the notice is acting as the local authority, rather than as some other body such as the landlord. If you widen it than that, further than that, then the local authority and the court have to carry out, well, for Mr. Manning's exercise of reading all the plethora of housing law material in order to decide whether in serving this particular notice, the local authority is acting as landlord or, in contrast, acting as local authority. So my submission is that the court should hesitate long and hard before it embraces a regime in which that sort of wide-ranging, the sort of exercise that Mr. Manning's been carrying out this morning, which is to try to convince your lordships that the whole background to housing is a set of conflicting, complex statutory duties imposed on a local authority. Therefore, it's a statutory animal dealing with a situation regulated by statute.
And
therefore,
I really will shut up in a moment, but just so I understand the landscape. Mr. Manning, I think, did put his case two ways. He says, well, he doesn't need to put the case the wide way, and his narrow way gives rise to the issues you're talking about. If you took the wide approach and said, well, wherever a statute authorises or requires a notice to be served and the person serving it is a local authority, that wouldn't give rise to those difficulties that you're referring to. It would mean, presumably, that a local authority could use section 233 in the context of statutory demands or in the context of party wall notices. Can you think of other major areas where that would be the case?
No, but I'll have a think. I mean, there will be a large. Your lordship's example is a perfectly good one. And the local authority will have functions in which it's necessary to pursue remedies in bankruptcy.
Yes.
Well, but is that the case? I wonder if that's true, because as always, when one tries to think of examples, objections arise as to whether they're actually truly analogous or not. So the problem with my lord's example is that bankruptcy and winding up are class remedies on behalf of the class of creditors as a whole. And one might question whether a local authority has amongst its functions acting on behalf of the class of creditors as a whole. Whereas in the case of housing, it has a very clear statutory duty to provide housing, including secure tenancies.
Well, your lordship says, I don't with respect, accept that dichotomy, because we're getting there on the basis of an hour and a half's exposition about Mr. Manning, which is, I mean, he's an expert about the expertise. I'm not meaning this pejoratively at all, but a very short survey in the nature of things, of the nature of local authority housing duties. They are a body which is a corporate body with ancillary powers under Section 111 of the Local Government Act. That was Mr. Maguire's point in the case in which Lord Justice Kennedy gave the judgment. So they can buy and sell land. They can provide housing outside the statutory scheme. They can do a whole mass of things. It's a big move to go from saying that the background to this involves statutory duties, which it does, and statutory powers, statutory discretions, common law powers, abilities to contract and so on, to saying that therefore any notice given in the area of housing by a local authority brings into play 233. And in my respectful submission, that has to be, as Mr. Manning came very close to accepting, where his submission takes him. He draws back from that to my Lord's second narrow point. Then each and every time the jurisdiction is invoked, someone will have to sit down and say, is this in truth just a local authority exercising a power in common with lots of other people, or is it exercising the public law function of a local authority? And it may be sensible if I could move, first of all, just to the way in which I put it on this statutory scheme, and then show your lordships the statutory history of 233, so that we can get a feeling for what's happening. So, if I take, I mean, for all its faults, the contrast which I wish to draw between a local authority acting qua local authority, and in this context, a local authority acting qua landlord, what are we dealing with here in this scheme? So if we go, first of all, to, yes, I'll come back, I need to go to the wording of 233 fairly obviously, because it's crucial, but I won't do it just yet. If I go, first of all, to section 80 of, no, not 80, the notice provision in the 1985 Act.
Meaning 83 ZA.
Well, yeah, it's 8. Yeah, 83 ZA will do. Yeah. Now, we know from 83ZA2 that the requirement of ability to serve the notice is placed on the landlord. That's the language of 83ZA2. So just applying the statutory wording, is the local authority acting qua landlord or qua local authority? There's some indication, it's not decisive, and I'll come to that in a moment, some indication in the language of the statute itself that it's acting as the landlord. That's its relationship with the tenant is that of landlord to tenant, and that's what creates the need in the statutory scheme to serve the notice if it wishes to achieve a desired effect. Is the landlord, could the statute have simply said the court must not entertain the proceedings unless a local authority has served on the tenant? The answer is no, because...
Why not, when one knows from the structure of the Act that landlord subsumes within it a number of classes, and
yes,
one of the classes, in fact the most relevant class, is local authority.
the biggest class is local authority. That I completely accept. It's the question of what the nature of the exercise that's being carried out is. I think the law put the example that we could just have listed, and I accept it as a theoretical possibility, within 83 ZA2, all the people who might satisfy the landlord condition. And one of them would have been a local authority. But I still submit, if that's been done, and you ask the question, is the body serving the notice acting qua landlord or qua local authority? The answer you get firmly back, it's serving the notice because of its relationship with the tenant in a statutory scheme which recognises the position of the landlord as such.
Can I ask a supplemental question on that? Mr. Manning explained to us that the landlord condition has been narrowed.
Yeah.
Housing associations have gone. Suppose it had been narrowed to just local authorities. So only a local authority could be a landlord for the purposes of a secure tenancy. Therefore, necessarily, any notice under Section 83 ZA would have to be served by a local authority. What would the position be then?
My submission is that in this scheme, it wouldn't matter. The history is not irrelevant. And indeed, the question that your lordship is putting to me assumes that it's a possibility that if you narrow the class of the people who meet the landlord condition down to one, namely local authorities, at that point, but only at that point, 233 kicks in. And that, in my respectful submission, is not how the statutory scheme works. And indeed, I would submit the same as the truth, even without the history. You'd still be looking at a landlord and tenant relationship, and the statute would still be addressing the role of the landlord in that relationship. I don't need to go there. I don't need to succeed in that submission.
No,
because
it's sort of parallel to Mr. Manning's having
yes.
various versions. But suppose it were the case that the landlord in a secure tenancy had to be a local authority. And fitting with that, in Section 83 ZA, it said that the court was not entertaining the proceedings unless the local authority has served a notice. Still, your case would be, because there's a landlord and tenant relationship involved.
My case would be, with more hesitation, I would accept. It's not actually our case. It's quite important to remember it's not our case. But yes, it would be. I mean, for that reason, I quite want as an early step to fit us into the scheme of the 1972 Act, which won't give us an authoritative answer to any of this, but it does envisage that the notice envisaged by 233 is akin to a public notice, or a notice given by a chairman of a parish council, as we've seen, and so on. It's that sort of animal, not a notice given by a landlord to a tenant.
So your submission is that we interpret Section 233 as limited to documents required or authorised to be served by a local authority exercising public law functions.
I'm not going to get tied to exercising the powers of a local authority as such. It's what
Yeah, well, see, that's where I have.
Well,
that seems
I know
to be circular.
Your lordship's going to say to me that's circular. I can see it. The phrase, it's very important in 233, and I don't think we've quite stayed with this ourselves in the skeleton, to recognise that one's construing, I suppose almost inevitably going to 233, but if we go there, 2331, it's the phrase as a whole that you need to construe. It's the same with notices. Any notice required or authorised by or under any enactment to be given or served on any person by or on behalf of a local authority. So it's not just a statutory requirement for a notice. It's a notice that is given by a local authority, and I say acting as such. Liability orders.
You go further, because the way in which you define acting as such is if it's exercising a public law function.
But that's because I myself naturally fall into that language.
I'm not sure how else you can discriminate, because as I understand it, the reason why you say acting as a landlord doesn't count is because that's a private law function, not a public law function.
It's got. I would accept that for 233 to play the role that I understand it to be intended to have, functions like the service of liability orders, which is the exercise of a particular statutory power available only to the rating authority who wants to collect the rates, are a notice. It's an order, a liability order. Required or authorised under the enactment, namely the Rating Act, to be served on any person by or on behalf of a local authority, namely the relevant rating authority. So that fits in relatively easily. No one else is a rating authority, or no one else is exercising that particular statutory power to serve a liability order. I think the Secretary of State may sometimes be the rating authority, but it will be acting under a different provision.
Coming back to where we were, suppose you had a provision that wrapped up the Secretary of State and local authorities, so it was all the same power. What would the position be there? I mean, the local authority would be exercising, as you say, the public law function, but the power would not be exercisable exclusively by a local authority.
Because some other public body could do it.
Yeah.
I think I would accept that the form, whether it's in two separate statutory provisions or one provision, seems unlikely that's going to drive the answer.
Yeah.
But I would be very reluctant to concede that without looking at the precise statutory language that was in play.
Yeah.
But are you almost saying that the statute itself has to refer to the notice being served by and using the language a local authority?
No, it will frequently use in case
a rating or whatever it might be.
Well, a rating authority or
Yes.
a local planning authority, yes. It has to refer to something that is identifiably the local authority exercising the powers that are giving rise to the need for the notice. So, I mean, it will. I imagine in rating law, I mean, I've done quite a lot of cases about rating liability orders in my life, but I imagine that one would trace through an ability on a rating authority so described to serve the liability order. Then you go to the definition section and find out who the rating authorities were, and they will be local authorities normally. And so, as I say, if you look at liability orders, are obviously a fairly common source of dispute about service because people move hereditaments and it comes up from time to time about what the scope of 233 is. So that if you do the Westlaw search, is an area where there is half a dozen cases which have raised 233. That's the scope of it. And the same is true of planning. Have you properly served your enforcement notice? And you'll have the same chain. You'll have a local planning authority.
But do those authorities address why 233 applies, or
No.
is it just in passing that as the factual background was that the notice was served under Section 233 or whatever it was regarded, the order or whatever?
No, there is no authority that discusses the nature of the 233 jurisdiction
Right.
in the way in which we're doing it.
Yes. But you're saying that the power under Section 233, if you look at the authorities, has been quite frequently used for the purposes of serving notices in rating or planning.
Yes, certainly. And I'm quite sure there will be other statutory schemes which are clearly identifiable as local authority statutory schemes, of which the same is true. We're not dealing with one in the Housing Act 1988 because of the range of bodies who either have been historically or who are now capable of fulfilling the landlord condition and the nature of the fundamental tenancy nature of the relationship. Now, can I now kind of move on and make good my My promise to go to the statutory material shows you the wider context. I've only got 2 clips. And there's one.
Hold on a second.
The 2 clips.
Yep.
One, if you look at the top of the first page, Local Government Act 1972.
We've both got that. But...
So they have. The one with the bigger print.
Okay. Yes.
is the 1972 Act.
Yes.
The second clip is my reconstruction this morning of the trail for the enactment of 233.
Oh, okay. I see.
And it starts with the printout of 233 itself, which is why it's got Local Government Act 72 on.
Yeah.
The footnote's got a derivation.
Yeah.
Which I followed through. So, looking at Local Government Act 72, we're in Part 11.
Yeah.
The heading is General Provision as to Local Authorities. And 222 is a provision that your Lordship may have come across. It's the provision which enables local authorities to seek injunctions in place of the Attorney General and related actions. It is obviously a power specifically aimed at the activities of local authority qua local authority, to use my terminology. And going on, Part 11 goes on to be concerned with 224 documents and notices, 225 deposit of documents in profit, officer of authority, etc., custody of parish documents, 266, so on. And then if we go on, we get to 232, which is dealing with public notices. That is shown in the note in the clip to which my Lordship went by accident a moment ago. 232 is shown as the successor to 287 of the Local Government Act 1933. So we're in a corpus of provisions dealing with public notices. Then we have 233 itself. And then we have 234, page 185 of the clip.
So do you submit that section 234 is restricted to exercising public law functions? What if the authority is authorised to enter into particular contracts?
Well, it is, but not under these. Sorry, where's your Lordship got to? Sorry,
234.
Yes, 234 is dealing with documents.
So would you accept that it covers a private law contract?
I don't actually know the answer to that. It's certainly dealing with authentication of documents on the basis of that are dealing with.
Well, the rubric is a little misleading because it's not just concerned with authentication. It's concerned with how the document may be executed in the first place.
Yes. Well, I'm going to harden up on the acceptance. I do submit that within this corpus of authorities, you're dealing with something for which the best shorthand we've come up with so far is a public law function, but specific exercise of a power granted to a local authority qua local authority, not seeing whether or not the authority is entered into by a binding contract. As I understand it, the rule about that is to be found in the normal rules about execution of contracts by corporate bodies. As someone with authority to decide it, entered into the contract, can enter into all the contracts, for example.
Coming back closer to the facts of our case, you say, there's a notice under section 83 ZA could not be authenticated in reliance on section 234.
Yes, I would. I hadn't thought about that before, but I certainly would.
Meaning, sorry, you when you say would, you say...
I would say that.
Yeah, fine, that's what I thought you would say.
You're getting it cross purposes.
Yeah.
As I say,
so it wouldn't apply in relation to the authentication of a section 83 ZA notice.
but I don't want in putting in this clip to get diverted too much into whether or not my basic proposition about the language of 233 reads across to each and every provision in Part 11. It's just to prevent your lordships, if I may put it like that, from approaching the matter on the basis that one's dealing with a very wide, a power that is very widely available and is drafted on that basis. It isn't. It's put into a piece of fairly specific machinery in part 11.
Yeah.
No, it's what I was looking for. We got to 234 by accident. The other power to bear in mind in this is there's a power in 231 at the top of page 183, which is the mirror image of 233. It's a power to serve a notice on a local authority. So that, for example, in the rating scheme or in a planning scheme, it will sometimes be necessary to serve the planning authority or the rating authority with
So,
notice.
on your submission, section 231 does not apply to a tenant serving a notice on his landlord if the landlord is a local authority.
Yes. And one of the areas of the case law that the Westlaw search reveals is some discussion of the boundaries.
Of section 231.
Of 231 as well as 233. But if you may have had a chance to read the wording, but they're very similar.
Yeah.
As I say, I don't want to make your lordships feel that I stand or fall by having an answer to the place in my scheme of each and every provision within Part 11.
Sorry to interrupt you mid-flow, but before I've lost the thread, can I just check? My Lord Justice Moylan asked you a question. I want to be sure I've understood your answer correctly. Are you telling us that there is authority which decides that section 231 does not enable a tenant to serve a notice on his or her landlord using the machinery of section 231 if the landlord happens to be a local authority?
I'm not saying that, and I would need to go back to the authorities to make sure that was clear, but it would be consistent with my case that 231 isn't the prime place you look to in order to identify where the notice is served. Sorry,
I understand. But you were saying that there are cases.
So
in contrast to 233, there aren't any cases other than ones we've got addressing its scope, but there are cases dealing with the scope or applicability of 231. Or there may be.
maybe it's probably accurate.
Okay.
If you're me, I've bumped around in both lines of cases to find some crystal clear principle. Okay. If I found it, your lordship would have it.
Yeah.
I haven't. issues have arisen under 231 as to whether, for example, there's a criminal case which comes to mind, which is where, in order for a young person to be prosecuted, the local authority, of a certain type of offence, the local authority had to give notice to the probation service. They had an oral conversation with the probation officer, I think. The submission was that 233 hadn't been complied with and was applicable. The solution was to say that there was nothing in 233 or general law to prohibit an oral giving of notice. So the issue didn't arise, if I can put it like that, so which is why I'm hesitant about answering the question. There isn't a straightforward statement of the boundaries of 231 and 233.
So can I just test it a moment? Suppose in a landlord and tenant context, and I can't remember all the different statutory provisions, there's probably one relating to service charges or something, or possibly here 85 ZA3 where that contemplates, or 85 ZA1 I suppose, a tenant may request a review. Suppose you have a statutory provision which contemplates a tenant of a local authority serving something on the landlord. Would it matter if Section 231 applied? I mean, suppose the assiduous tenant finds out about Section 231 and says, well, I'm going to comply with Section 231. Would that matter?
Would it produce adverse consequences?
Yes.
I don't know. I mean, I would need to think that through. But it's not the normal role of 231.
But
why not? I mean, what's the problem with 231? Seems like a perfectly sensible provision. What's the problem with saying tenants can use it?
Well, as I say, I think the question's never, I don't think, achieved a final resolution. As I repeatedly say, I'm not going to the wall about whether or not 231 is of wide scope or not. It's just that you approach 233 on the basis it's part of a range of provisions which have an identifiable role in relation to, can't do better than the public law roles of local authorities, the operation of statutory schemes by a local authority acting as such.
Yeah.
Is that a convenient moment?
Yes.
Excellent. So we'll start again at 2 o'clock.